In his paper titled Understanding Traditional African Healing, Mr. Mabuye Mokgobi from Monash University, South Africa, stated that traditional African healing has been in existence for many centuries, yet many people still seem not to understand how it relates to God and religion and spirituality. Some people seem to believe that traditional healers worship their ancestors and not God. It was therefore the aim of his paper to clarify this relationship by discussing a chain of communication between the worshippers and the Almighty God. Other aspects of traditional healing, namely types of traditions, as well as the role of traditional healers in the communities were discussed, go far beyond the uses of herbs for physical, not limited to counselors, social workers, and disadvantageous that as the only healthcare workers in the workplace environment, we are not equipped with the necessary training and serious world of spirituality and be able to do our patients or employees justice while helping employers navigate this enchanted territory. I welcome you to our first webinar of the year, colleagues, with a promise that today our eyes will be opened and we'll never approach this interesting subject the same way. My name is Dr. Didi Mkwanazi. I'm an exposure scientist, healthcare educator, and most importantly, a colleague of yours. I practice professionally as an occupational medical practitioner, travel medical practitioner, and economic risk assessor. Today, my mission is to represent the Occupational Health and Exposure Sciences Academy in saving workers and empowering employers by training the occupational health practitioners. Can you hear me, colleagues?
Yes, we can.
Correct. Thank you. Today's session is proudly brought to you by Occupational Health and Exposure Sciences Academy in partnership with corporate and industrial medical consultants and Moeletsi attorneys. Colleagues, we also acknowledge and show gratitude to our panelists for sharing their knowledge with us this evening and urge you to reach out to them after this session and benefit from their expertise. Let's just go through a couple of house rules. This session is accredited for 1 CPD point by HPCSA for registered participants. In 2024, we issued a total of 27 CPD points, that is 23 general and 4 ethics points in total, and we are intending to achieve more in 2025. Kindly please drop your HPCSA number, full names, and email address in the chat box to register for CPDs. For those who are not registered with HPCSA, growing knowledge provided at all times to avoid interrupting the presenters, not be able to ensure that you YouTube. Colleagues, go back to our YouTube page to recap on the information. Also urge you to post your questions on the video platform to continue empowering colleagues who will always be able to access our learning material. We really thank you for your continued support during live presentations and digital learning platform. Participants will be allowed to ask questions or comment after each session. Questions can be posted in the chat box anytime during or after the presentation. Our sessions are multidisciplinary in nature and meant to empower colleagues from different professional backgrounds. Kindly please be patient during moments when we discuss topics that may not be relevant to you, but others. Sit back and relax, colleagues. The webinar is about to start. Colleagues, last year when we hosted the first session in this series, you showed us how important this topic is. And today we are back with the second installment, which focuses mainly on the legal and medical aspects related to African spirituality in the workplace. At the end of this session, we'll all have a brief discussion on the urgent matters regarding this topic and continuously answer the rest of the questions on our YouTube learning platform. Following the success of our previous risk assessment course in November 2024, we are happy to introduce the two much-needed courses that we will host on the 27th and 28th of March on medical surveillance and risk management. This will be held at our studio in Vereeniging, and as per tradition, will cover the theoretical and practical aspects in these two subjects. The objective of these short courses is to refresh our knowledge and skills on our legal mandate, on our two legal mandates as occupational health practitioners, which is medical surveillance and risk management. These two courses will be accredited for a total of 5 CPD points each by the HPCSA. Details and registration link can be obtained from ohesa.dlp@gmail.com or on WhatsApp number 064 520 3301. I repeat the number 064 520 3301. Only a few spots are available, and please attend to it as soon as possible. We're also having a comprehensive economic details communicated closer to the dates, and restrictions are also there. Presentation of the day, please allow me to welcome Ms. Takamba Moeletsi, who holds an LLB degree from University of the Free State, LLM degree, that is Masters in Law from the University of the Free State, postgraduate diploma in management, specializing in business administration and commerce from Wits University. She's a member of South African Society for Labor Law and former secretary of South African Women Lawyers Association in the Free State. She's currently the director at Moeletsi Attorneys, which is a labor law firm. She's a founder of workcourses.co.za and Effective Forces Consulting. Please, when you have time, you can Google this to see how they can be of assistance to you. She was previously employed at Amnesty International South Africa as a working group member, Bowman Gilfillan Incorporated as a senior associate, ENS Africa as a senior associate, Mineral Council of South Africa as acting deputy head, Cliff Decker of Meyer Incorporated as legal consultant in the Department of Employment. Colleagues, let's welcome Ms. Moeletsi. Good afternoon, Kakamba. Can you hear me?
Good afternoon, Danky. So can you hear me? I can hear you well.
Yes. Are you going to share on your side or should I share?
If you don't mind, continue sharing. I just want to check a few things because while you were speaking, there were times that you were breaking. And I'm not sure if I'm the only one who experienced that. The reason why I'm asking is that if I need to change my network at this point, I need to know if that was because of my current network and I need to change, or we can continue and then people will just let me know and you can WhatsApp me if there's anything. I think nothing is more frustrating than you're talking and you think people are on the same page as you. In actual fact, they just have a frozen screen.
Yes, no, you can proceed. I don't think it was you. It wasn't you, it was me.
Okay. All right. All right. Thank you. I can see that. Good afternoon, esteemed members of our society. Growing up, we used to give a chair to a doctor or a teacher in our profession. So I greet you as most esteemed members of our society. And thank you for the opportunity to present to you this afternoon on an interesting, very interesting topic. And I look forward to engaging with you as we go along. So I'm tight for time. I feel like I'm in a clinic and there's lots of patients and I need to try and create some diagnosis and solutions in a very limited time frame. So please bear with me if I don't get to everything this afternoon. Thank you very much. Thank you. So as an overview, because I know many of you were probably asking yourself the same question that when I said to people, I'm going to be coming to this webinar to speak on this topic, they said, what angle? What angle? A very difficult one, but I will cover some relevant legislative framework in South Africa, obviously zooming in on the labor relations aspect, because that's my area of speciality. We will talk on the most prominent issue, being this issue of medical sick notes, and so much that has been published on content to do with the issue of traditional health practitioners that are now going to be able to issue certificates. I'm not sure if the concern is around competition in the market or what this means. I mean, there's so many concerns that arise from this issue. So we're going to cover some case law and some thinking around practically what happens. And then we're also just going to look at some cases that touch on some topics that Dankiso and myself discussed concerning some place scenarios that we tend to face, of people coming in into a surgery or whatever might be the workplace scenario. And of course, you have an opportunity to ask questions, because I understand some people have to leave, whether they're starting a different shift or whatever might be the scenario. So for some, we'll just have a few minutes, perhaps move on. Next slide, please. First thing I just wanted to indicate on, as we wait for the next slide to just come up, is, the topic was site diverse, and it wasn't easy deciding on what issues we wanted to cover today. I mean, I was in the thick of things, as many labor practitioners were during COVID, which had so many incapacity inquiries. And it was interesting to me when this topic came up, as much as it covered spirituality, that, if time allowed, I think in the future one can talk about some of the lessons that perhaps we can pick up from what we all had to endure during COVID. Of course, issues of spirituality and so forth do raise issues of religion and issues of, dress codes in the workplace. I just wanted to highlight some of the things that were coming to my mind and some of the people that I was speaking to. Of course, the most prominent in the social media space is the question why so many celebrities have been choosing to become what you call, sangomas, and whether these are related to any mental health issues, and how people generally in society view these issues of mental health issues. But of course, would have discussed them in more depth in the context of the workplace. I've been dealing with a lot of mental health cases in terms of depression, bipolar matters, and so forth. So I would have also appreciated the opportunity from you to get a sense of how we approach those things when dealing with them. Of course, we get together and we get our heads together. It's good to know what we can share in that regard. And of course, the issues of discrimination, they're also vast. We do touch on them softly as we deal with some of the issues in today's topic of spirituality, and the need to reasonably accommodate people, whether it's for religion purposes or whether it's for ill health issues related to spirituality, needing to transition for whatever processes. So yes, took a lot of thinking to try and narrow things down, but I'm grateful for those who were able to contribute. Now for today's topic, if we can quickly move to the next slide, please. We in South Africa are a global society, of course, and much of what happens in the context of the developments of legislation in South Africa is at times influenced by what happens to the organizations that South Africa may be signatory or members to. And such organizations are the International Labour Organization, which often issues some guidelines. An example that I've been dealing with a lot lately has to do with harassment in the workplace, and it's because of an ILO convention that was issued, that South Africa had then issued its own guidelines on bullying and harassment in the workplace. But the ILO recognizes traditional medicine, and the ILO, of course, deals with matters in the context of the workplace. So together with and it relies obviously on the World Health Organization guidelines on how it looks at these things. So that is at least the starting point from a legislative view. And of course, in South African context, the main law that we always have to cite, no matter what other current legislation, everything flows from our constitution. Of course, many of you would know that the constitution is the supreme law of this country. So as much as we deal with issues at a primary level, everything flows from our constitution. We look at, we're going to talk about section 15 of the constitution, and, we're going to talk about section 23, which deals with right to fair labor practices, the right to religion, and quite widely quoted during the issue of COVID when we were dealing with ill health and capacity. We dealt with section 36. Someone needs to mute, please. Could we please mute?
All right.
List of speakers who are not speaking? Okay. So the important thing is that as we look at these things and we analyze them, these are the premise that we use as our compasses in the legal framework. So we look at the constitution and whether rights can be limited. And of course, I'll delve into detail by what I mean by this in a practical aspect. I just wanted to give a helicopter view of what informs the decisions we make as lawyers. And of course, we have the Labor Relations Act, where many of the instances in cases where people get dismissed in issues of, them having produced a medical certificate from a traditional healer, as we see in one case. Many of these cases end up in the CCMA. We deal with instances under the Labor Relations Act in terms of, whether this issue concerning this employees, this was one of automatically unfair dismissal, which is actually about discrimination. So many of the claims we'll face will then come under the labor relation umbrella. The Basic Conditions of Employment Act is, of course, relevant in the context around this issue of the medical certificate, whether we can accept medical certificates that are issued by traditional health practitioners. And of significance is, of course, the Section 23, and we will deal with this in much detail. And of course, what we have seen a lot that has been in the media has been around these traditional health practitioners and the process of getting them registered, which falls under the umbrella of the Traditional Health Practitioners Act. Currently, you would have seen since June last year, there were regulations that were published, which involve, the registration of these traditional health practitioners to be able to become registered, and who qualifies to register, the membership, because effectively they're trying to develop structures that are, of course, similar to what you have in your council with the health practitioner, HPCA, and pharmacy councils, nurse councils, and so forth, and all those bodies. So we have, of course, an important act, the Employment Equity Act. So how employers approach people, how you approach people, this issue of the Employment Equity Act has different sections, of course, but most relevant in this context are the sections that deal with equality in the context of the workplace. How we look at traditional health practitioners in the context of the workplace, people who are sangomas. Some people feel like, I can't work with this person in the same office. There's instances where we've had to face scenarios where they say, no, I can't be in an environment with someone who's wearing beads and so forth. And it's, we need to ensure that people are treated fairly in the context of a workplace. So a lot to be said, colleagues, with very limited time. So I'm not going to try and talk too much. We can move on. Next slide, please. Thank you, sir. So much has been said, much has been done. There was research done sometime in 2007, FutureWorks, which tried to establish, what is happening with regards to why people approach traditional health practitioners. And they noted that there were various reasons people feel comfortable. I mean, I saw one report that talked about 80% apparently of people prefer to go the alternative medicine route and not necessarily. So it's quite interesting, this context, and hence I just included the quote for some context that we have to accept that people do resort to treatment from traditional healers for various reasons. All right, let's move to the meat. what's the meat? It's hard to talk as a lawyer without saying, I am saying this because, establishing a basis for which I am making these assertions, which I'll make after some of these cases. So to be able to do that, there's the case that I want to take you through that is widely cited in dealing with this issue of medical health certificates that were submitted. So briefly, the facts are as follows. Ms. Moledi was employed as a chef. She was fourth in charge at Kivis Kroon Country Estate. She was undergoing training to become a traditional healer. She initially asked the employer if she could stop working in the afternoon and be able to work, only the morning shift because she needed to do her training. Then she came back and said to the employer, well, now I need to go through the final stages for me to, be able to complete my training, and this needs 5 weeks. She went to the employer with a letter, from the traditional healer indicating that, this is a life or death situation. She's been having, what's it called, permissions of sorts that, of course, require her for treatment to undergo this training. So she left all of these things. The employer said, I can't give you 5 weeks off. This is a busy period. This would not be possible. So she said, well, this is a life and death situation. So she left. Effectively, after she left, of course, the employer said, if you don't come to work, we will discipline you. She ignored all of that and continued with her training and said, listen, I'm not coming back. So at all times she would respond. They charged her with effectively 4 charges. But the essence of those charges, of course, were disobeying instructions to report and were centered around her absence from work without permission. Of course, she then went through a disciplinary inquiry, which then found her guilty of those charges against her and ultimately dismissed her. When she went to the CCMA, the CCMA was quite sympathetic towards her, and effectively the commissioner there said, this is an employee who's facing a life and death situation. This employer was unreasonable, failed to consider, the employee's circumstances, was very much focused on their needs, and did not try and understand that this is an illness, and did not understand that if this employee did not undergo this treatment, this could be a life and death situation. So the commissioner then said the dismissal is unfair because the reason for it was unfair, and reinstated her. Of course, Kivis Kroon was not happy as an employer because it felt it had a legitimate basis to deal with this, because an employee just disappears for 5 weeks in circumstances where they're not permitted. They went all the way to the Labour Court and the Labour Appeal Court. From time perspective, I will not deal with what was said there. Effectively, this went all the way to the Supreme Court of Appeal. Next slide, please. The Supreme Court of Appeal analyzed, because the other courts effectively also all looked at what the commissioner was saying. But effectively what the Supreme Court said is that once it is accepted that the respondent experienced visions of her ancestors and used traditional healing methods because of sincerely held cultural beliefs, as the commissioner correctly found that she did, the line of question he pursued with her and Ms. Masilo regarding the possible consequences had she not attended the course was not only understandable, but unavoidable. So a whole issue about, assessing why this person, the defense that, well, I couldn't obey this instruction. I couldn't come to work because, I was facing my medical condition. And the court will say, in this regard, it is well established that when an employee absents herself from work without permission, and in the face of an employer's lawful and reasonable instruction, a court is entitled to grant relief to the employee if the failure to obey the order was justified or reasonable. So effectively what the court says, as you would know, is that when a person issues an instruction, a manager, a senior person issues an instruction, that instruction must be lawful and must be reasonable. If it is not lawful, meaning it obviously for whatever reason, and it is not reasonable, then that instruction effectively becomes one that an employee would be entitled not to comply with. And here the court said the employee was entitled not to have to comply with that instruction because it was not lawful and reasonable. And especially around acknowledging the person's defense. What is important here is that, what is being said is we need to look at the person's belief and assess whether these are, sincerely held beliefs in something, right? And that's what the court said is the measure. For us, they said you can't go into the mechanics of some of these things, and we don't, as judges and jurists look at these things, but we need to look at whether the person's belief, are sincere, and whether there's perhaps an ulterior motive for this person invoking this belief. You find in many instances this issue of dreadlocks is a classic example. There are instances where people are just using Rastafarian as an excuse. They're not necessarily following that religion, but they will invoke that. And there you need to look at, has this person even been practicing this religion and so forth, for them to invoke any sense of, this is my belief, and get the protection from the Constitution under Section 15. So importantly, though, and the comment on paragraph 31 is that the court still said that, an employer is not expected to tolerate an employee's prolonged absence from work for incapacity due to ill health. The court wasn't saying we are condoning that in every instance an employee can disappear and then bring back a Sangoma certificate and say, this is the reason. But they said the problem here is obviously they didn't approach this from an incapacity and ill health issue. And that was what was distinguishing, because if they had followed that, perhaps the outcome might have been different. Don't know if we have any questions. I've got really a few things to cover in a few minutes. Are we going to take questions now? Are you still with me?
Please proceed. We'll handle questions afterwards.
All right. So, of course, it was interesting and much debate has been coming from that case, because many people judge it based on as if the employer was bound to look at that medical certificate and accept it for what it was. I think the only parting comments from that, and they flow into this Traditional Health Practitioners Act discussion, is the fact that there's two things to take away from that Kivitz-Kroon scenario and where we are right now. The first one, that when you are dealing with an issue of either misconduct or ill health incapacity, the medical certificates of traditional health practitioners, if they submit it as a defense to say, this is the reason why I've been doing the things that I'm doing in the office, making the noises or walking barefoot in the office, in the face of disciplinary, in the face of those processes as a defense, they are something the court says you must look at, because people have, as I highlighted, if you look at from the Constitution perspective, the right to religious and conscious beliefs. So they may be acting and conducting themselves based on those beliefs that they have, and so that's one part of what we're looking at. The second part is around this sick leave certificates or medical certificates. My apologies. And there, where things stand is that we have this Traditional Health and Practitioners Act that was registered in 2007, but the council hasn't, there is an interim council, which are busy, they've been busy with roadshows, and I think they've concluded the roadshows, but that process of having members register for Traditional Health Practitioners has not been finalized. So as things stand, as far as I know, but please, if there are people who are more on the ground, from my research, I'm answering from my research, desktop research that I have done, that process hasn't been finalized. So from the perspective of an employee seeking to say, here is a sick note from my traditional health practitioner, I'm entitled to sick leave and to be paid sick leave under the Basic Conditions of Employment Act. That is a different scenario that is not yet catered for. So they can't claim to have that paid sick leave under that provision because it falls under the umbrella of the Basic Conditions of Employment Act. But in the context, as I've said, of misconduct, of whatever scenarios where someone comes with a defense, around, I'm undergoing treatment, I have a medical condition. I hope you understand the distinction that I'm creating. So this is the significance of this act in terms of elevating the status of traditional health practitioners to that of those recognized under the umbrella of the Basic Conditions of Employment Act. There's someone who's not muted because I'm getting a bit of an echo. I don't know if it's just me.
Please proceed. I'll mute them from my side.
All right. And that's the context of elevating so that people can claim they paid leave, which they're entitled under legislation, the Basic Conditions of Employment Act, and of course assess other benefits that are related to recognize, forums that we have, such as your specific HPCSA bodies. So the point of this is to elevate, obviously, and provide protection and recognition. As I've indicated, the World Health Organization recognizes traditional health practitioners as, of course, health practitioners. So the act, the Traditional Health Practitioners Act, they say is to get rid of those, scrupulous people that claim to be practicing traditional health practitioners, formalize the sector, and it does so by establishing a Traditional Health Practitioners Council that would be assisting with registration, with conduct, so the requirements for registration, out the qualification standards. We know this is a contested area, but it's something that council obviously sets out the guidelines. It also provides for disciplinary process or for people to lodge complaints, against unscrupulous practitioners. And interestingly, I found this, it had a provision that says it can do inquiries in respect of the mentally impaired registered person. So it can, decide to do inquiries on its members who may be mentally impaired registered practitioners. I found this interesting because I've never come across any membership body that specifically expressly highlights this as a requirement. I'm really interested in the memorandum that explained why some of these provisions were there. But maybe it is, I'm not aware of this being highlighted. I mean, we know it forms about normal processes. If someone lodges a complaint and these things would be done. But be that as it may, there are regulations in place that have been published. There have been road shows, and it seems that finally things are finally coming together in terms of formalizing the sector. But it is a work in progress as far as I know. But I'll be interested to hear. I hear some colleagues are practicing traditional health practitioners. Talking about this poster was interesting to me, for many reasons, but maybe it's a conversation for another day. We have time constraints. We can move quickly. So there are various cases that have looked at this. I mean, Dolongo is almost similar to the previous case of Kivitz Kroon. And what was interesting, this is before the Labor Relations Act, but they're the employer, how you approach it. And the only thing I wanted to highlight is that where you approached by an employee, here an employee disappeared for 5 months and came back with a letter that was written by the traditional health practitioner that said, I write on behalf of this person, and this person has been undergoing training, and this is why they disappeared effective for 5 months. So they said, if you look at the wording, this is not a person saying, I've diagnosed, I am treating this person, which was, one of the things that was interesting and highlighted in this case. But they upheld that dismissal because of various reasons, and the issue there wasn't so much about that sick note, but I'm just making reference to it. The issue was more of the, they were absent, and the employee didn't pursue much regarding that sick note in that case in any event. An interesting case of TFD Network Africa has to do with religion. This person was a Seventh-day Adventist, and throughout the recruitment process, apparently had communicated that she would not be able to work Saturdays. But there were monthly stock takings, and for the most times, this person was not rostered to work Saturdays. And then someone picked up an issue with it, and eventually, this led to a disciplinary inquiry for her not coming on Saturdays, and she was ultimately dismissed. And the court found her dismissal automatically unfair because they said they were discriminating against her on the grounds of religion. Because the reason why she couldn't work were related to a religion. And for that reason, it found that the employer, and this is the important thing in the test around dealing with these cases, there were several managers. It's not like stock taking would not happen if this person was not there. Because there was a distinction between this case and one that concerned Muslims. And in that case, they said basically the factory would shut down if the Muslims didn't, if they were allowed to then practice their religion on that day. So they felt that if we had to balance the employees' interests in terms of their right to religion versus the business need to continue, in this case, they said, but stock taking was continuing. It was clearly, and basically that was the distinction. In that case, they said the factory would have to close, and therefore, the employer was right in dismissing those workers. So context matters in how we approach these things. But yeah, that was the thing about TFD. And of course, we have the Department of Correctional Services and another versus Police and Prisons case, widely cited to do with dreadlocks. And again, there, what is important is the reason that's given to you. Why am I doing this? And these people gave various reasons about why they had to have dreadlocks, even though they're correctional services officers, even though there was a policy that says we have to be neat because, they made a whole case about safety, and so forth, because obviously prisoners could pull these dreadlocks and stuff. But here, looking at it, the court felt that there had been discrimination for various reasons, because there could always be accommodation. People could always be moved to other places. They just felt that the policy was not well justified. Instead, it seemed to restrict these members' rights. Okay. How we're doing on time? I think we've almost come to the end of our talk. The thing is that there are many approaches that one can take, of course, consideration of some policies, because what we find, you can go to the next slide, is that, employees sometimes benefit from policies. When you know the rules, I have a situation, I'm able to go and read what are my options. And one of the things that, have been interesting is, of course, even though you can't claim sick leave, if you go to a traditional health practitioner, you have to take annual leave as things stands. The things that companies and organizations try to do to be able to curb some of the anxiety that exists for some people, around these issues. I saw there's, companies that implement mental health days, there's sabbatical leave, there's menstrual leave, paid menstrual leave days, additional sick leave. So there's always means to try and minimize the impact of some of the things that you see in your environment, and a consideration of how to best manage that. All right, thank you. Sorry I had to rush, but we really had limited time frame to try and cover much of the content that we wanted to cover.
All right, thank you very much. I totally do understand. The reason being, this is a very interesting subject for most people, and for some people, it's an untapped territory that we hardly ever go into. But nevertheless, that was very informative, and we thank you very much. I'm just going to ask that we give the next speaker a few minutes. I promise it's not a long presentation, and then we can have a discussion shortly after that. Is that okay, Kakamba?
Sure, yes.
Okay. Okay, colleagues, please allow me to welcome Dr. Mathabo Hlahane, a multi-award-winning medical practitioner who has a Bachelor of Medicine and Bachelor of Surgery from Nelson Mandela Metropolitan University. She's currently a senior medical officer at the Department of Health. She has been involved in numerous pioneering health projects and served in various leadership roles since her days as a medical student. As a student, she became the first female vice president of Africa for IFMSA. She's the co-founder of SADC Medical Students Forum. As a junior doctor, she moved up the ranks in South African Medical Association to being the projects officer for senior doctors as a National Executive Committee member. She's currently a co-founder of IPP NWSA and an international counselor who sits on the General Executive Board for the K Project, which is also called Climb Kilimanjaro for Peace. She is also serving as the current Secretary General for Junior Doctors Africa, part of World Medical Association. Her keen interest is youth empowerment. Sahani has a long-standing labor movement background and also exposure in private practice as a medical officer in the mining industry and as a flight doctor, as a pillar lead for human rights and traditional health professionals.
Latter part, the less, I hope.
I just want to put up your slides.
No problem.
Okay, thank you. Just a sec. Okay, colleagues, in the meantime, you may post your questions in the group chat. We will deal with them immediately after Dr. Sahani's presentation. I just want to find it. She just emailed it to me. I'm seeing Dr. Obaking's comment. Dr. Obaking. I think the three of us know why you were saying net, but I think it's net here. Almost there, Doc.
No problem.
Okay, it's loading. Something should be coming up soon. Okay. Up questions here. Right after Pelani for that line on YouTube. Healer. Not all answered in the meantime.
We lost you again, Doc. Sorry to say.
Okay. As Dr. Mkwanazi said, my name is Dr. Matabo Shahani. I come to this platform wearing various hats. I'm just trying to find it. Dr. Mkwanazi, are you able to control the slides from your side, just to show the next slides?
No, Doc.